What?
Mouse.
Okay. It's just a work session, it's not a formal meeting, right?
Right.
All right, so I guess I'll call this work session to order. So we'll start with the interview process for Sheela Stack and Bill Wambacher or Wambacher? Wambacher, thank you. So I guess we'll just start. I'm not the lead interviewer, that will be our mayor who's on her way, but I'm trustee Hunter. I've been on the board for less than a year now. I work next door as a local civil engineer. And then we have trustees Check and Heck. And Mayor Smith will be.
She isn't going to make it for this one.
Not for this one. Okay, so it's just us. So if you could just start by telling us why you'd like to work for the town of Paonia, that'd be great.
Yeah, you want to go first?
Sure, I'm happy to start. So, we have done a lot of work on the Front Range for municipal water plants. And that's really our bread and butter client. We are in some of the most challenging, most litigious cases in the Front Range of Colorado. Most cases that we file in water court have anywhere between 20 to 50 opposing parties. We have some very good clients that are really pushing the envelope on the Front Range. And what we've learned over the years is that we have a lot of expertise that I think from that kind of contentious environment that we see on the Front Range that we think we can bring to other parts of the state and really be successful and helpful for other municipalities. So we have been looking in the last few years for opportunities to try to bring our expertise to other areas of the state. And so, when we saw this RFP come up, and especially all the comments about how challenging the water system is, and certainly, the challenges you've been facing both on the water rights side, but the engineering side, it got us excited that this is the kind of project that we like to be involved with, because we like very challenging projects. And that's what gets us excited about the work that we do. So that was one of the big things that jumped out for me.
Yeah, the other thing is, what we love about what we do is our client. It's not just the town, it's the relationships that we build with our clients and with our consultants. So one of the things that we were really drawn to is being able to work closely with a small group of trustees, the director, the mayor, and an engineer. And you right now, from what you went through in 2019, you're really reevaluating your whole water system. And we love being part of the water planning, design, and then implementation. And having a team together to be able to either improve, add on, extend, and to get to see that's our project, and that we've been a part of something that was so important. And I think what drew me to water law really is you get to see the fruits of your labor, that I get to show my kids, and I get to show that I have helped a town, which for a place like this isn't just your customers, it's your family, it's your partners, it's your neighbors. And it's something that we take very personal. We make sure that our cell phones are available. We answer calls on weekends, evenings, because we are personally invested with our districts, even though they may be municipalities. To us, it's a person that we're connected with, and we're really close with our engineers also. And so seeing your complex spring system and really what you're doing now and trying to reevaluate and make your system more efficient, and also just collaboration with local water companies, other governmental entities, that's really what we love to do. We are very good in water court. We're good with what we do in a litigious situation, but our real strength is negotiation, collaboration, and I think we pride ourselves on holding ourselves to a higher standard and being accommodating and reasonable.
Great, thank you. I think what we'll do is we've got set questions, so we can just round robin around the group. Does staff have any, I mean, clearly I've never done this before, so any recommendations as far as how to run the show?
So there are 7 total questions. These are scored. Maximum points available are 100. When we ask the question, I think it's good for them to know how many points that question is worth.
Okay.
We've kind of touched on some of the questions already. But yeah, if we want to go round robin, since there's only 3 of you, if you don't mind, I can ask some of the questions too. Would you like me to start?
That would be wonderful.
Okay, so question number 1 is worth 20 points. It's one of the more highly scored questions of the 7. Please describe your experience addressing issues regarding water rights, water and sewer infrastructure, and water availability for residential users or other pertinent water issues affecting the western slope.
Sure, there's a lot we can say there.
Yeah.
So our 2 currently our biggest clients are municipal clients. We represent the city of Loveland. We represent East Cherry Creek Valley Water and Sanitation District, which is a water district near Centennial, Colorado, and then also Arapahoe County Water and Wastewater Authority. And so the work that we've been doing, and I'll give you this background just to kind of give you a sense of our experience there. They started both of those, excluding Loveland, but those water districts for the longest time have used non-renewable groundwater as their source of supply for their citizens. Well, in the Front Range of Colorado, that water's not going to be there much longer. And so 20 or so years ago, they decided we need to shift our entire system. We can no longer use this non-renewable groundwater. And so for the last I've been involved for 8 years. You've been involved with this project for longer than I have. For the last 20 years or so, they have been working on shifting their entire water supply from wells to changed water rights that use water from the South Platte River. And so what we have done for them is we do changes of water rights. So they own ditch shares of various ditch companies spanning over 100 miles of river in the South Platte. And so we do changes of water right cases for them. I think we've done 10 of those.
Yeah, we're looking at about 15 now in the last.
Okay.
Yeah.
About 15 of those we do water rights cases for recharge rights. We do exchanges. So their systems rely heavily on moving water within the natural environment. And so they do have a pipeline system, but we do a lot of work using the South Platte River and the tributaries to move the water. And so we do applications for exchanges of water rights. We have reservoirs that we do water rights for. We do groundwater rights for them. I mean, you name a type of water right, we've filed an application for these clients to do that. And so our bread and butter really is municipal water work to serve residential demand. We do the exact same type of work for the city of Loveland. Do you want to add anything?
So then taking it from the South Platte River to find those renewable sources, our district clients also have their wells in district. And so not only do we find out and figure out how to get this renewable water into the plant and deliver it to the district so they get redundancy, we now are also taking a look at their in-district wells, evaluating all those wells and deciding which wells do we need to rehab, which wells are we going to now use for deep injection. So one of the Arapahoe aquifer wells that we are using, we've permitted with the EPA for deep injection. We want to be able to look at aquifer recovery. We want to know what we can do with aquifer storage and recovery. So you don't have a wasted asset with your in-district wells. And we're also trying to figure out some of the Laramie Fox wells and some of our wells that we may just need to replace pumps and do some other rehabilitation. Are there ways that, what we call it is Armageddon? If it's the worst case scenario, the RO plant goes down and we still need to rely on our district wells, what do we need to do in the actual district to make sure those wells are being used to their highest and best use? And so we not only are thinking about trying to find them a renewable source, it's what can we do with the asset that we have already? And so we work both with the South Platte River and then what we're looking at with the actual aquifer in our districts.
One other thing I would add, would add to that is, I think this was one of the things that sort of drew us to Paonia too. So when we were looking at your system and trying to figure out what we could from what was available online, and we saw, there's a spring complex over here, there's pipelines over here. I mean, you have a pretty diverse and spread out system, which in a lot of ways it's different, but it's very similar to what we have with other clients because they have water rights literally spanning hundreds of miles on the South Platte River. And we work with a great engineering team to figure out how, from a water rights perspective, do we make all these different sources talk to each other? So at the end of the day, we have a good water supply from this well field that all of these other sources augment at the end of the day. And so there's some similarities, which is what made him, again, going back to what I said before, it made me excited about working on this project.
I have one follow-up question, and it's a little technical, so sorry. I guess it's not. How did these districts decide on moving forward with deep well injection, and what was your role in that?
So for the deep injection well, we worked with our hydrogeologist, and that became a real thing in the South Metro area. Looking at the Arapahoe Aquifer, there's the South Metro Water Supply Group. They all got together. We realized that we have these deep wells. Everyone is looking on the South Platte River for renewable sources, but East Cherry Creek was the first to get the Arapahoe well number 7 permitted with the EPA. And so we started the pilot project to see if it would work. And so far it's working, and others now are waiting. Because we're a partnership with the South Metro area, this is something that we should have. You need to figure out, again, if the plant shuts down, what's the next step? And that's really what we love about what we do, is how forward thinking it is. And working with our engineers, again, we started working on what we call the well decommissioning study with them. I started working on it in 2015 with one of our districts. And as that decommissioning, we categorized all of the district wells, and one of the categories was targeting which would be the most ideal to convert to deep injection.
With that pilot, was there any federal funding that was obtained?
No,
So
we
this is
didn't.
all,
Yeah.
okay, thank you.
Yeah.
Can I ask a question?
Sure.
Okay, I'm sure I'm not gonna ask it, right, but my background. One of the, and I'm the only one on the board, really super concerned about it, is the wetlands thing. And you've had experience dealing with the EPA and all that sort, haven't you, with water quality? I know you have. And but the town, from when it was originally settled, was moved up the hill. Main Street was half a mile that way, and there used to be a bridge there back before the flood in 1909. And Main Street, the happening street, didn't change the name. It's 3 blocks from where the Main Street was. There was many houses on it. And then we do have floodplains. You're talking, my background, I'm a farmer. Floodplains are real obvious. And I got a feeling we're heading for some problems on our water discharge. And you had experience with that, regs and stuff like that, haven't you?
Are you speaking to your discharge permit for your treatment plant, or what we were talking about is whether the dredge and fill rules will start to apply with some of the improvements?
Are you talking stormwater?
Yeah.
Stormwater.
Yeah. So, the MS4 permits and your stormwater discharge permits, the monitoring and reporting requirements are becoming more and more difficult. The state is over budget, understaffed, and what we're seeing in the stormwater world is really just excessive, burdensome requirements on the permittee. And so you're correct with your limits. And the next time that you have to come out and renew your stormwater permit, it's possible that more onerous conditions may fall on you. We've been seeing that with the new general permits coming out, even individual permits that are coming out. The state is trying to make a standard now on reporting where, you know, towns like yours are having to find 1 or 2 full-time employees now just to go out and inspect. It's becoming, but it's falling on deaf ears. We've tried through stakeholder processing to explain that these towns cannot afford to have the town administrator run out there and track down an illicit discharge. But they don't seem to care. What we've been hearing is we don't have the staff. And so it's up to you, permittee. And we've tried with, again, stakeholder processing. You do a budget, the cost benefit analysis showing what it will cost a town like this to meet those conditions. And we hear the same thing from the CDPHE is, why don't you just work with us? Give us a call if you're having struggles with investigations or inspections or compliance deadlines. We're also seeing compliance schedules. They're giving you years out to try to figure out to hire somebody or how you're going to get all of your monitoring reports into place. It'll be hard. I think anyone that has new permits that are being replaced or amended or renewed are seeing more onerous conditions. I mean, we're seeing them in well replacement permits. Simple wells are being supplemented or replaced, and suddenly there's these new restrictions that sometimes counter what the decree says. So it's difficult, and I will add, that's one of the benefits we do see from the town hiring a front range attorney, is that we are there. We have a great relationship with the state engineer and the attorney general. We're meeting with them in June to talk about concerns we have. We're right there with the CDPHE and able to go in person. And we personally feel that in-person meetings, even getting through the time of COVID now and how Zoom meetings are so much easier, there's nothing better than the in-person connection. And we find being there and having those meetings with administrative bodies is really important.
Right, that spawned 2 questions, or really something else for me. We don't have an MS4 permit yet,
You don't,
so we don't have any discharge. We talked about that earlier today, that it's coming. But then, were you guys part of the Akron discussion a few weeks ago? They brought some communities together in the Front Range to talk about these general permits from CDPHE.
Words.
Okay, 40 communities on the Front Range got together for this, so.
Did you have an additional follow-up?
That was it.
Okay.
I asked. Okay.
Trustee Heck, would you please go ahead and do question 2 as well on the list? Thank you.
Question 2. Yeah. I get that one. Okay. Tell us about your most conscientious negotiation and how it was resolved. In addition, please describe your experience with ADR, the Alternative Dispute Resolution.
And just to clarify, that's contentious.
Yes.
And this one's worth 10 points.
Is it follow-up too?
Let's do that first to start with.
They'll just finish the mediation. So
Yeah,
they'll
so
speak to it.
I can speak to the alternative dispute resolution. So we have a case pending right now. One of our municipal clients is trying to do a change in water rights of some ditch shares. The ditch company has what's called a Catlin bylaw, which is a bylaw, I haven't seen many on the west slope, they're in the Front Range, where if you're a share owner, you cannot go to the water board and change those shares until you go through an approval process with the ditch company. So we submitted all the documentation that was required by that ditch company. They refused to look at it and then told us, no, you cannot change the shares. And so we were forced to file a lawsuit. They just didn't want these shares changed. And we ultimately, they did not want alternative dispute resolution. We went to the water judge and said, will you please order alternative dispute resolution in this case, because we think this is something that can be resolved. And so just last month, we spent 2 days of mediation with them, and I was just looking at the emails today, we are close to finalizing a settlement with them where essentially they're going to buy water for us in another ditch for us to change so that they can kind of keep us out of their system. And so just actually earlier this week, the trial that was scheduled to start in June, we have delayed now to give the parties 6 months basically to try to find alternate shares to avoid litigating this fight between our clients and the ditch company. And so that was a tricky one because one, not only did the ditch company not want to engage in alternative dispute resolution, but they had very strong feelings about not wanting our clients to change the shares. And so we were unsure that alternative dispute resolution was going to help. But ultimately, I think we've gotten there. I mean, there's still work to be done. We have to find these alternate shares, but that just happened last month. So that's why that one popped into my head.
Yeah, I will say Riley Carlock hired me because of my negotiation skills. One of the partners actually said I would never be a partner because I'm too nice. But I always approach things when we can reach a resolution. I don't believe in, unless we are absolutely at a standstill and you have to go to trial, then that's where we are. We just had a case, we filed it in 2016. It had a change of water rights, it had storage rights, it had recharge rights, exchanges, it had everything, and we had 58 opposers. And, you know, in the beginning of my career, that was very daunting. I would hunt everybody down, beg them to call me. And really what we have fine-tuned now is providing draft decrees and then just picking up the phone and give me language, let's talk this through. We encourage our engineers to talk. When it gets closer to trial, we always encourage our clients to call the managers themselves, because sometimes managers don't know what's going on. They get updates in board meetings, but you know, when it gets very close, that seems to be a last ditch effort of maybe you should call and just have a one-on-one, get the attorneys and the engineers out of it, and we always encourage that. But really, we approach every case using alternate dispute resolution matters. We believe in negotiations and talking things through. And you start a case and see 60 objectors and, oh my God, how are we going to handle that? But when you start to break it down, when you've done this for as long as I have and Bill has, it's, you know who the attorney is, and let me give him a call, and you know who the engineers are. You also know the entity and what their real issue is. And so sometimes we can get ahead of it the minute we see the statement of opposition and we can realize where their water rights are or what they have pending. You can figure out and acknowledge what their concerns are. And I guess I'd say for our most contentious case, again, it was a ditch company bylaw. We tried for 5 years to get a Catlin approval. And our first meeting, the ditch company president, I've never seen someone turn redder and the expletives out of his mouth telling us to leave the room, that we weren't changing his shares and to get out. So we left, we gave it a breath. We tried and went back to the drawing board. We submitted again, trying again. We got a no. And then fortunately, I am good friends with the ditch company's attorney, and she called me and said, what can we do? We need to change the dynamic here. Someone is triggering someone else. And so we showed up on a Saturday, and I just sat there and let all of the farmers said, just vent. Tell us what your concern is. Let's talk it through. And we were there all day Saturday. We ended up being the very first change case. Instead of taking the shares, taking the water through og stations and out the river, we now have built recharge ponds on the farms. So all the water is historically getting delivered as it was. None of the farmers are seeing any difference, and we're taking it by recharge credits. And I would say it was probably the first change case that the ditch company went to trial on our side. And the judge commented on that they had to file a statement of opposition, but they sat on our side. And having those farmers and the ditch company president and secretary get on the stand and say how supportive they are of what we're doing, you know, for me, sometimes they just need to vent, and you need to let them, this is hard for them when they see a municipality coming in. And although they can come in hot and upset, they're entitled to their feelings.
When I would say in that case, the reason that went to trial is because there were other opposers that were attacking what the ditch company wanted to do. And so we were in trial together with the ditch company, and we were successful in that. And at the end, the ditch company was thankful because we won the case. So it was a huge shift.
And it was
the
their
attitude.
first change case.
Yeah.
They never had a change done.
Okay, the follow-up question's a little redundant, but I'm told to ask it anyway, so here goes. What is your experience with negotiating with CDPHE or other state federal agencies on permitting?
So I've had a bit. We had a greenhouse in Morgan County that wasn't aware of discharge permit requirements. The Department of Ag had a well that was downstream from this greenhouse, which obviously tested very high for biosolids and TDS. So the ag guy followed it up, found the greenhouse. We were able to negotiate monthly monitoring reports. We had to enter into a new discharge permit for them, have conditions and inspections, and were able to negotiate their original civil penalty. We got down by 65%. In just working with them. We have another client that had an MS4 permit that had some other phase one. We have 3 phase one permittees. When the new permit came out, being able to negotiate those terms when the stakeholder process was going on. The phase 2 general permit, we worked with the Colorado Stormwater Council on that phase 2 permit. But mostly now, we work on and get phone calls from people that have received notices of violation and cease and desist orders. So again, having those relationships with the CDPHE staff. Right now, we are working with a developer that received a notice of violation. We met with them, received the initial offer, and this is the first time in my 20 years, they actually emailed and said they want to meet again. They have reevaluated and would like to present something else. And so I find that to be really comforting. The fine that they originally gave these developers was, 6 figures. I was not expecting it for what they did. It seemed like it was more administrative issues, but they put down the hammer. And so we went back, took photos. We drafted a response that was 23 pages just to counter everything they said that these guys did that violated. And I feel like CDPHE staff really took that into consideration. So we're meeting on Monday for their new offer.
Another thing I would say too, and I don't know if this is the kind of negotiation that the comment has in mind, we've also been involved in rulemakings before CDPHE. So there was a nutrient rules for reservoir rulemaking a few years ago. We were part of that hearing. And as we were talking about before this started, the state last year passed their own dredge and fill program. So we were involved in drafting that bill and adding a lot of the carve outs for irrigation ditches and some of the maintenance things for water rights. And right now we're actively engaged in that stakeholder process for the rules that are going to come out from under that new law.
I do. So number one, we really like rulemaking. We tend to get involved in rulemaking on the federal level as well. So, but with that greenhouse, was that an industrial pretreatment permit that you were working on with them?
No, they had it was a tomato greenhouse and they had just a CDPS discharge, yeah.
Okay, thank you. That was.
And I'll do the next one and then you can take after me. So question number 3, and this one has a point value of 25. Paonia has been described by a previous water attorney as the most complicated system in terms of water rights in Colorado and perhaps the entire Western United States. What is your experience with advising municipalities that have consecutive water systems and balancing the need to protect the water utility with the needs of consecutive systems?
Good question. Yeah,
It's also the most, it's 25 plants.
Yeah.
So.
Yeah. So we have a client that is a consecutive system with Denver Water. So we're familiar with the requirements of the wholesaler and the supplier and what that means. One of the interesting things that we were looking into for the town was your meter system and what other supplies these water companies and HOAs are having, and the responsibility on the town, and what that means when you are the responsible party. You've got the operator in charge, you're in charge of the monitoring and reporting, reading the meters, and delivering the finished product to these companies. For us, really what's important is the drafting of the agreement to make clear what your obligations are and your responsibilities, and what those suppliers' responsibilities are. A lot of these companies just expect the water to be delivered to them, and that's it, right? But the details have to come into the agreement so the conditions are clear and you understand. One of the things that we were curious about is whether or not you'd consider becoming integrated. Would there ever be a situation where it'd be a shared responsibility? And yes, it is a unique system that we have not seen, with all of your springs and the collection boxes, and just driving around to notice the pipe system. It is something that we've not seen before. But again, on the Front Range, we have hundreds of miles of different diversions, and we've seen complex. This is just very unique. But we do appreciate the consecutive systems. You know, we have, between our two clients as well, our one client delivers to our other client that serves commercial customers. And so we understand the obligations between two public water systems, and then what your responsibility under your domestic treatment permit is going to have on you as well.
I don't have anything to add on the consecutive system piece, other than I think just to reiterate, I mean, really the work we do on the Front Range, I would argue is some of the most complex systems on the Front Range, just because of the scope. And so certainly what you guys have here is different. But like I said at the beginning, I mean, those are the kind of projects that we work on day to day now. And those are the kind of projects that we enjoy working on because of the challenges, because of the need to have close relationships with the client, with the engineers. My background is in engineering, so I love the overlapping engineering and legal issues. Like, that's really where I feel like I excel, because I can play a little bit in both worlds to the extent that I need to.
And as a follow-up, what is your experience with negotiating and renegotiating contracts and agreements with consecutive systems that may not want to reopen their 50-plus-year-old agreement?
I read that in your report card. Well, again, I believe it's in the relationships. I understand if they don't want to renegotiate and open, I would look at the terms of the original agreement, and if circumstances have changed, you also have the opportunity where you will no longer serve them. If that needs to be an opportunity and that needs to be what you have to do to get them back to the table, again, we never believe in, you know, throwing down the gauntlet when you need to or having bad neighbors. But at a certain point, you have to weigh if it's necessary to renegotiate because of the changed circumstances, and that there are new operations that need to be contemplated. If there's new obligations on their side, and that's why they don't want to come to the table, if some of the burden needs to shift on them. We would want to take a look at the agreement on how do you amend, how do you terminate. I assume 50 years ago, it's a pretty short agreement to maybe nothing. And so walking away from the agreement, do you cut them off and have them come to the table and threaten to sue? If it's an option.
I got a few.
I'm sure there's follow-ups to this.
Executive systems that we service. We have 32 springs that make up our spring complexes. All of them most of these consecutive systems have given up some sort of water right for clean domestic water. So there's some give and take. We currently have 11 agreements with the 23, where one of them is an actual agreement. The rest are the consecutive systems bylaws. So there is some serious need to actually get agreements in place. Out on the western slope, handshake was kind of how things happened.
Sure.
The good news is we do have a water rights, what I call a compendium, where it shows all of our water rights, what we're able to take, and how we arrived at those water rights. So that is available. Those contracts are available. But knowing that there are no, I mean, we might as well just say there's no real agreements but one in place. Does that change anything for you guys?
So there's no agreement dictating the terms on which the city provides or the town provides water service to these.
There's quite a few of the 23 that don't have an agreement, other than they may have filed a pre-annexation agreement.
That's actually what I was gonna ask, because you just said they gave away or exchanged some water rights, which to me is a pre-annexation agreement, like groundwater dedication when you annex. And so my other thought was several of these consecutive systems that you have certifications with the CDPHE that cross-reference yours. And so you already have a joint obligation amongst each other. If you were to have to notify CDPHE that you are no longer a consecutive system, you're no longer providing the domestic water to them, they're risking their certification. And I would think that's one of your hooks. But the other is, yeah, that's what just rang in my head, is if they gave up water or dedicated, you at least have to have a pre-annexation agreement where the intent was there for them to connect to you because they offered you something in consideration. And so getting them to the table under that would make sense to me. And I guess the other part, yeah, as a consecutive system, they have their own supply. Did they give up? They didn't give up all of their supplies.
It depends.
Mm-hmm.
Yes, they did. Some they have, some have retained some for like irrigation.
Okay, yeah, we saw the ditches and some of them, and assumed some of those companies. We saw there's the Burgess Water Company, you've got Hidden Valley. Yeah, but that was one of the curious things is you had a few, so it's 23 current, because I was reading you have 3 that are exempt now, that sent letters to CDPHE to become exempt. And that's exempt from being a public water system, not necessarily that they don't want to connect to you,
right.
But they didn't like being designated and having those obligations.
Yeah, and those are ones that they've been removed and we direct bill. There's maybe 7 or 8 of those.
Yeah. But that, I mean, if you say, if you're asking if it changes our mind if we're concerned, not at all, because I see you had the intent because you gave something in consideration. There has to be a pre-annexation agreement. Also, with their certification with the state, they've already acknowledged they're a consecutive system. I mean, I was looking into some of the certifications, pages and pages and records that are cross-referencing your permit. So you have to memorialize that.
Okay. Thank you.
Do you have any further follow-up questions? Trustee Huck?
No, I could write a book on it.
Trustee Chuck, any follow-up questions to this one? Or just when we move on to the next one?
Sure. A sense of urgency can at times compromise thoughtful decision-making and a thorough process. Can you think of a few examples when this has happened and what was your role?
And this is 10 points.
Yes.
Evaluations.
So the question is how a sense of urgency has changed your thinking about something?
No, a sense of urgency can at times compromise thoughtful decision-making. So can you think of an example when you were under pressure to because of an urgent decision was necessary?
Well, certainly, I mean, we've been in several trials where things are happening fast and furious. And you have to be able to make decisions on the spot under stress. The judge may have made a ruling that no one was expecting, and now you have to completely pivot in the middle of the case. We had a trial a few years ago where the trial was stopped in the middle of it because the judge requested that we negotiate on one piece of the case. And so then out of nowhere, we had to shift from trial mode to now trying to negotiate a long-term agreement to avoid the trial and to avoid having the judge make a decision on it. And so that required, an immediate shift in thinking when we were preparing to go to trial. The other thing I would say is I provide testimony down at the state capitol on water legislation pretty routinely. I've been down there twice this year already. You have to be on your toes sometimes when you present at those hearings because you get very interesting off the wall questions. So again, that's just another situation, maybe it's more of thinking on your feet. But we find ourselves in those situations, frequently. And so it's not foreign. And so when it happens, we've seen it before. And so we're usually able to rise to the occasion.
Yeah, I have two examples. One, again, in trial, we knew after we closed our case in chief, we could sense that a motion to dismiss was coming. And I think this really speaks more to just our chemistry and the way we work together. We knew it was coming. We turned to our paralegal. She already had started to do the research. She started to pull up the argument. And then we knew once we closed, opposing party stood up, said his thing on the motion to dismiss. The judge asked immediately for the ruling then. Sometimes he'll take a break and say, maybe I want to hear arguments the next day. I want written briefs on it, but we stood up, and because we work so well with our paralegal, she called our associate to start doing research. She started to write. She found a motion that we had done before. We won on the motion. We survived another day, and it was phenomenal. But because we're just really good lawyers and we stay calm under pressure, but also can't do it without our paralegal, our associate. And because we're so small and nimble, being able to pick up the phone real quick or text and just say, hey, I think we're getting dismissed here. We're trying to buy some time. We've got about 15 minutes. What can you do for us? The other total one-off for a client of ours, I'm helping him with his horse operation in Texas. And we have an issue with equine infection anemia. It is, and I'm learning all sorts of things about this, but unfortunately it's fatal in horses. And the ranch manager called me immediately. Her initial reaction was, we just found out 2 horses are tested positive. We're gonna get quarantined. What do? They called me on a Saturday panicking. They were gonna try to take their prized stallions off the ranch before the state came. And I said, nobody is moving a single horse off this property. We officially know that we are positive. We have to work with the state on this, try to quarantine the horses. I started looking into the regulations. We figured out the regional director, and they called, panicked on a Saturday, and it's everybody stay calm. It is what it is. We're gonna follow what the state protocol is. We'll get a specialist down in Texas to know and get them in place to help you on Monday. And, the original reaction is, how do we save what we've got here? And it's really unfortunate that these horses have to be put down, but everybody stay calm. We're just gonna do what we need to quarantine. We got on Google Earth. We figured out the lay of the ranch. We told them to move fences and how to handle it. And the state's been out 3 times now, and so far so good working with them. But, I think we have clients and consultants that call us and they can be in a panic, and it's very important for us to take a breath and make sure that they feel reassured that even if we can't give them the answer right then, give me a second. Let me talk with Bill, which is often what we do is, hold on, let me talk to a few people. I'll call you right back. Don't do anything.
Yeah, I think that's a call question as well.
Yeah.
So I guess we'll move on to the next question.
I don't like that one, but can you, this was only worth 5 points. So the next 2 are a little bit more. Can you describe an example of a time when your legal opinion helped bring a positive outcome?
Yeah, the title opinions, I think, are really important. Bill does a lot of real estate diligence work. He does a lot of title opinions. We find a lot of individual homeowners and developers find a piece of property, you should speak to it, you're the expert.
Yeah, so I mean, what I was thinking too is, so one of the things that I do for free, and I've done this throughout Colorado for about the last 8 years, is I give presentations to real estate groups about water rights and the importance of doing water rights diligence. Because over the years, I can't tell you how many calls I've gotten from someone that's bought a property with water rights or well rights, and something has been screwed up. And it's usually something that could have easily been fixed as part of the transaction. And so I have been doing what I can to try to educate some of these different real estate groups to help their clients address some of this stuff on the front end, so that we don't have all these problems, because there's a real gap in education. So that's something I think that is paid. I'm hopeful that it's paid dividends. That helps the community. We've also been involved, like I said, in a lot of legislation at the state capitol. And so, I think in some of those instances, it depends on, which community you're talking about. But we have done a lot of work over the years on water legislation, making sure that residential water users and ditch companies and ag folks are protected from legislation that has been proposed. And so we work with a team of lobbyists, and we have for years on issues down at the Capitol. And so that's another, I think those efforts certainly have widespread effect, both in our local community and statewide.
That would have been my follow-up. I'm changing that follow-up for future is lobbying experience in itself. So keep going. Yeah.
I would say our firm is probably one of the few water rights firms that year after year is active down at the Capitol. And that's because we have a team of lobbyists we have worked with for, how long is Bob? 15 years, 10 years. And so I've been involved with this group for 8. So we're active in the Colorado Water Congress group. We also go down and meet with elected officials independently. I'm actually supposed to be going to Israel in May with a group of elected officials from Colorado for a trip that's sort of a networking thing with elected officials, different business leaders and lobbyists go. I went on that trip several years ago, and assuming it actually happens in May, I will be going again. And so we are, I would say our firm is probably the most active in the lobbying legislative realm, probably than any water rights firm in the state of Colorado, honestly.
And I do think what I admire about what Bill does, we have municipal clients, we have individual and developer clients, but when we are proposing these legislative changes, we always think about the ag industry. We do consider the environs, and what Bill does so masterfully is negotiates that to find a compromise for language where everybody's leaving something on the table. And that's why I think he's asked time and time again from different lobbyist groups and from the actual legislators that call him and want his opinion when they're drafting bills. They run it through him to get his opinion, and it's because we've been so respectful and acknowledging all the different interests.
One other thing I would say is I noticed, I think you guys had a conversation about tap fees recently. And so I'm actively involved. There's a tap fee bill that's moving through right now. It only applies to special districts, so it wouldn't apply to the town. I'm actively involved in that, and actually was part of a group that gave an education presentation to a group of elected officials just a couple of weeks ago on tap fees and what they cover and how they're structured and all those things.
Recently had some problems.
So Provo West is in trouble, is that what you're talking?
What's that?
Provo West is in trouble.
All right, trustee Heck, you're up with number 7.
It's actually 6, but it's number 7.
Oh, I get to do, got it. I get to read that one?
Yeah.
Okay, please think of a time when you had to redo a work product because it didn't meet standards. What was the context and outcome?
15 months.
So I have drafted agreements before, memorandum of agreements. And in particular, I was working with a project manager on an agreement and missed the mark. And really where I took the blame from it is I wasn't fully in the loop on what the project was. The project manager had given me the overview, he gave me a survey, gave me an idea of what he wanted, and so then I took to pen. What I learned from that was there has to be a series of follow-up questions to really understand what the end goal is and what's the purpose of this agreement, what are we seeking to accomplish. And after the first draft, it went up from the project manager to the president of the company, and it was, look, this is not what I wanted. I sat with the president of the company and said, I'm a really good writer, and I felt like I was back in law school giving D- work, which to me was really upsetting because I take real pride in what we present to our clients. And I appreciated being able to sit down with the president of the company and say, tell me about this project. What am I missing here? Here's my understanding. And then he filled in the blanks. So I took to pen again, and what I provided to him, I sent it directly to the president. He said, this is the Sheela that I know. This is what you've gotten. And so what I walked away from is you can't really just rely and say it was someone else's fault. There's got to be a follow-up to it, and you've got to be able to do your homework. When I was given what the executive summary was, I should have done deeper, really should have asked a lot of follow-up questions. I've done this for a long time. And so now I know, when working with this particular project manager, here's everything I need to do. But also, again, what we love about the town is what you're doing now will be on the ground up. We're going to see understanding the system and then the improvements and how it all connects. It's not just an isolated project that you're drafting for. It's what does this do 20, 30 years down the line? And then what was the original intent? And what are we trying to do now? And so that was a good learning experience for me.
Yeah, and one thing I would say too is I think, especially in the water rights space, it's important to admit when you're wrong. Because these are complex issues, they're mixed issues of law and engineering. And if you're overconfident, cocky, you're not listening to your team, you can end up pushing forward a case that's not going to be helpful to your client and has lots of problems. And so we have certainly been in situations where we've started with a water court application where we think, okay, this is the right approach, this is the right idea. And then we get into a case and the 30 opposers say, we don't like it. I mean, they always say they don't like it, but sometimes it may be more justified than others. And so we've certainly had instances where we started down one path in water court and realized, okay, this is probably not the way to go. We don't want to push this. Let's go back to the drawing board with our team, and we've amended applications and backed up, because I think it's important to recognize sometimes that you can be going in the wrong direction. And that's why, certainly why Sheela and I work together as a team. We're constantly putting ideas off each other. And same with the engineers that we work with. I mean, we look at it as a collaboration because these are complex issues. Everybody's looking at it from a different perspective, and having all of those ideas, especially in a complex situation like you guys have, all those ideas are important to get into the right solution. Yeah. So you can't have too much ego or pride in most cases.
And I will say, one of the things that we learned, we draft these decrees, we work with these engineers, and then we send it to our client. And it's, yay, we did it. What we started to understand is operators didn't know what we were doing. So I was getting phone calls of, hey, they drilled these 5 wells. Well, you can't drill those 5 wells. The decree says you have to do X, Y, Z first. So Trent in the operating field is like, I don't know what you're talking about. So what we've started to do is we do these lunch and learns with our clients. And we open it up, we cater the lunch, and it's the operators. It's customer service, operators, plant operators, the drillers. They attend these lunches, and we'll put on a topic for something that district is working on, so they understand it's not just me and Sheela saying, you can't drill those wells. They want to understand why is that and what is it that we're working on, so they feel they're part of it. And we have realized you have to remain humble, and it's not just because it's a legal document that it's our territory. Everyone has to have ownership in that. And the lunches have been great. We have operators now calling us randomly and just, I'm curious about this. I'm like, thanks for calling. I'm happy to explain it to you.
Let me just ask on timing. Is Muni Court after this? What time do we need to clear the room by?
Just talking about.
Oh, yeah, we-
I felt the twitching.
Muni court starts at 3.
Okay, so we have,
Sorry, we went over, yeah.
No, it's
we
okay.
can wrap it, so I'll.
We
I'll
don't need
move
that follow-up.
No follow-up, and then
Last
I'll move on to
question.
question 8. Okay, so this will be the last one. This one's worth 15 points. Please describe how many municipalities you are personally representing at this time, and will you have any scheduling conflicts that require others to serve in your place?
So our 3 municipal clients are the ones I talked about. So the City of Loveland, East Cherry Creek Valley Water and Sanitation District, and Arapahoe County Water and Wastewater Authority. And, the workflow for those clients ebbs and flows. And so, we'll have a big application, we'll have periods where we're doing expert disclosures, we're really busy, or if we're getting close to a trial, God forbid, we may be really busy, but the work ebbs and flows. And the way we manage it is Sheela and I really work as a team. And so with respect to those clients, we'll kind of split up, they may have 3 or 4 cases pending at the same time. So Sheela will handle this one, I'll handle this one, and we'll try to find a balance. And so I would assume we would do the same thing here. And so I don't think there's ever going to be a situation where somebody from the town calls and we say, we can't talk to you for a week. I mean, we are very responsive. We return phone calls in 24 hours. It's not a situation where you're going to send an email and it's going to sit in our inbox for a week. I mean, it's just not how we do business. And, if it's something, if there's really something going on, we have a trial or something, we're not going to ignore you. We would tell you, and we would come up with a contingency. And we have a good team behind us too. And so you're never going to be without representation or someone that you can talk to.
Yeah, that is one thing about being a small firm. We meet often, but we also look at what cases we have going on. Bill talked about the case that went into mediation. That's his big case. We know when that trial is. We don't often then shift all of, Bill will have all of the trials in 2026. We sit down with our paralegal and our associate, and we look at what the workload is, and then we divide it up. And so, if he's got a lot of trials, then I am open and free, and I'm the one that will take the burden of all the other clients and let them know and make sure that they're taken care of. But again, even our trial years, when we are incredibly busy, we don't ignore the other clients. We are able to manage. I think that is one of the things that we pride ourselves on is you just work a little bit later and then your weekends are gone, and our families understand that. Bill's got younger kids, and my kids were when you started, my kids were 3 and 1, and we had a 1-month trial, and you just adjust. You get up earlier, you stay later, and you don't miss your family events, and it matters. It matters when the clients matter to you, and we work really well and make sure that the burden's not just on one of us.
And I don't think we've ever had a situation where something has come up and it's like,
I
I can't do this. Sheela, take over this case that you've never seen. I mean, when we allocate the work internally, we're looking ahead because our water court trials are scheduled 2 years ahead, 3 years ahead. And so we're always looking to find how to find that balance between everyone. And so, you're always going to have someone you can talk to, and it won't be a situation where you're just being pawned off to someone.
Well, and I think it also goes to what we said about just being humble. We also know our strengths and weaknesses. And so I would never put on Bill, you better learn stormwater real quick here, bud, because I'm super busy. And, when he does the legislation and the lobbying and dredge and fill, he's bouncing things off of me, but that's his expertise. And so having that sort of partnership, we make sure that you get the best of the service that you're needing and who is the expert that you need to talk to. We're never one to have pride of authorship or this is my client, I'm the one that's only going to be the face. And so you'll always be taken care of.
Anybody have any questions?
Actually, it's not pertinent to this question, but a few questions ago, and that was when it comes to subsidiary water companies, if you have a memorandum of understanding or there was some kind of agreement that wasn't a formal contract, how much legal difficulty is that, or how much does a memorandum of understanding hold legally?
Well, I think that also goes to the terms. If it's a memorandum of understanding, that's the parties expressing that they wish to do this. And so we'd always start with, it was the intent of the parties to memorialize this into a more complicated agreement. Some of the times we would record the memorandum and then the detailed agreement does not get recorded. So there is case law where you can find that it can be binding, still at least showing the intent of the parties to write something even more complicated. I mean,
And you can have implied
Yeah.
contracts too, and so even if there's nothing written, so, you know, I understand the challenge that you guys are facing because you have 23 or 27 different districts that all have different factual circumstances that led to that water being supplied to them. And so, you know, you kind of have to unpack the factual history of each one of those pieces, and that will dictate how you move forward. Because if there's something in writing, well, that's a starting point. If there's nothing, what, is there any history that we know? Is there an implied contract maybe that could be inferred from historical interactions or course of conduct over time? I mean,
that's what we started to do. We started to look at your water companies. Well, first we found your domestic permit, then we searched your domestic permit and cross-referenced to find the water companies. And then we found a document that had a list. And so then we started taking notes of each of these water companies, who has to be exempt, who has an agreement. I think it was Hayes, that was the 50 years, Burgess, and started to figure out, okay, now we see how this is all working. They don't have agreements. I think it was the departmental report card had that you are seeking the agreements and here's what's in place and here's what you're planning to do for 2023 and 2024. You know, it seems daunting, it seems overwhelming. You're gonna have to go and negotiate with each of these, but if you have the intent, there's water rights, there's an MOU, you're serving, there's ways to get your foot in the door and start showing that there was either an express or an implied contract.
Well, yeah, and I was curious too, like what if, you know, the person who made the original agreement was gone now, and some other new owner or something
Yeah.
took
We've
over
dealt
without
with that.
having a signed contract or agreement with them. So it gets.
Yeah.
we had a recently in a big dispute we had an old agreement with the ditch company, and a new manager came along and said, well, I didn't sign that agreement, so I'm not gonna sign it.
He personally did not sign it.
He personally didn't sign it. So, okay, well, this is.
Can I do that?
Yeah.
That's what I said. Wait a minute, is that a thing?
All right, well, I think we better end this and clear the room, but thank you